Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
One of the topics you talk about on At the Lectern with some regularity is about clemency decisions. And I have to admit, when I read about those, I sometimes wonder why I should care. But when I read a little bit deeper into it, I think it's a fascinating question. But because of how it dovetails into the Chief Justice's legacy here, and also as you've drawn out on your blog At the Lectern, there was a difference in the Supreme Court's tendency to deny more of Governor Brown's clemency requests compared to Governor Newsom, who seems to have sailed through with just about all of his clemency requests. And so I wonder if you could first kind of tell our audience a little bit about gubernatorial clemency requests in California, and what is the court's role there? Why does the court have a role in clemency decisions?
Well, they have a role because the Constitution requires it to have a role, the state Constitution. The federal clemency power is extremely broad. The president has extremely broad power to grant pardons and commute sentences. And Congress has no oversight over that at all. And the Supreme Court has no oversight over that. Under the California Constitution, however, the governor's power of clemency is still broad, but it is a little more circumscribed than the president's. If the Constitution provides that if the governor wants to grant clemency to someone who has been twice convicted of a felony, that governor has to first get the 4 justices or more of the Supreme Court to sign off on it. So the governor, when he wants to pardon or commute a sentence for a twice convicted felon, he has to send a request to the Supreme Court asking for the court's permission to go ahead and do it. And you mentioned that the court denied some of Governor Brown's. There were 10 times right near the end of Brown's term that the Supreme Court said no. That has not continued into Governor Newsom's tenure. He's been, except for he withdrew one request, but otherwise he's been 100% successful in getting the Supreme Court to okay his clemency requests, recommendation requests. And in fact, there was even one that the Supreme Court granted when Newsom submitted it, when the court just a few years earlier denied Governor Brown's request for the same guy. It was the same prisoner. I think it was a commutation of a life without parole sentence, and the court denied it when Brown submitted the request, and then under Newsom, the court granted it.
Right, and you've written that the court's denials of clemency requests from the governor are, quote, essentially court determinations that the clemency grants would have been abuses of gubernatorial powers, end quote. And that suggests that a denial is rather significant. And is the court required to provide reasons for its clemency decisions, particularly if you're correct that they amount to a determination that this would be an abuse of the governor's powers?
They are not required. There's no requirement to explain their grants or denials. And that abuse of power language comes from an order that the Supreme Court itself issued before any of these denials. They, on their own, without asking for briefing or anything, or without any apparent catalyst, they issued an order, published order, I think it was about 10 pages long, where they in detail explained their role as Supreme Court justices in the clemency review process. And they said, this is a very deferential review we're going to give to governors' requests for clemency recommendations. And the only time we're going to say no is if we think this is an abuse of gubernatorial power. So the denials that came, I think, I don't know, about a year after they issued this order were very striking, because based on this order explaining their role, the denials equate to a finding of abuse of gubernatorial power, but
Right.
they didn't explain why, which is one of the few things I have criticisms of the Supreme Court on is their lack of explanation. In fact, I remember seeing a quote of Governor Brown. They asked him, about these unexplained denials, and he said, well, look at some of the grants and look at the denials, and you tell me what the rule is. So he was perplexed. He has no idea why some get denied and some got granted, and that's just not a good thing when the governor himself doesn't understand the ground rules for how these clemency recommendation requests work.
Yeah, when the governor makes the clemency request, does the governor support it by any kind of statement of reasons or grounds?
Well, that's a separate issue. The file that he submits is submitted. He submits it. The governor submits it with a request that it be filed under seal, and it is. And the Supreme Court has automatically filed it under seal, and they will entertain motions from third parties to open up the files, in which case they will then send the file back to the governor and say, okay, justify, keeping all of this or parts of it secret. And but without those third-party motions, the file stays secret.
Right. Well, so the Chief Justice's legacy on clemency requests is in the black box, so to speak, because we don't have the reasons for why they're granted or denied.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.